Okay, I think we'll kick things off there. As soon as I start talking, someone else joins. I'm in that awkward situation, but we'll go for it and start. So welcome everyone to today's House Percival Housing Snapshot webinar. Our topic for discussion is freehold management companies and estate service charges. So if we turn to the first slide, Katie,
The fear of technical issues now have started.
It's a slick operation, as you can tell. Here we go. So headshots on the screen show our specialist social housing, property and housing management teams. We have got some first-time attendees on the webinar today, which is really great to see. And we've also got a first-time host. So obviously I'm Jonathan Parker, Legal Director, and I'm joined today by Katie Redding, who's an associate in the team who joined us in the last couple of months. So just a couple of things to cover before we begin. As usual, there is an opportunity for you to write in with any questions that you may have during the webinar. And to do so, please use the Q&A function that you should see at the bottom of your screens. If you have any technical difficulties at all, at any stage, please do let us know using the chat function and we'll try and help. So as mentioned, today we're looking at estate management companies, how they operate, the risks involved, what it means for affordable home ownership, and generally just things to look out for. As with many of our topics, this is another one where we could probably talk about it for hours, but with just 30 minutes, we'll cover as much as we can whilst trying to leave some time for Q&As at the end. But if there is any interest in us going into more detail on any of the areas that we cover, please let us know in the feedback form at the end of the webinar, and we can either pick these up directly with you or factor them into future snapshots. So we will start by taking each topic in turn, the first one being freehold estate management companies, and specifically what RPs need to know. Over to you, Katie.
Thanks, JP. So as we know, there are on most neighbourhood housing estates, there'll be some form of communal infrastructure, whether this be public open space, roads and footpaths, play areas, foul sewage, surface water drainage, and related infrastructure. Now, some of these will be adopted by local authorities and utility companies, and they will continue to then maintain them in the future. However, a question is raised as to what happens to the infrastructure that's not going to be adopted. What's going to happen to it in the future? And this is when we need to then consider what arrangements need to be put in place. Now, there's some debate as to why not all communal infrastructure is adopted. One view is that local authorities and utility companies simply just don't have the budget to be able to do so. An alternative argument is that house builders don't have the funds to be able to build this infrastructure to an adoptable standard and then meet the initial adoption costs. Where there is public open space on a development, then there'll be a requirement to set up a management company to maintain this and transfer it to the management company once the development is done. And this will be set out in the Section 106 agreement and be a landowner's obligation. Now, where the communal infrastructure is not adopted, one of the usual mechanisms to deal with future maintenance is to use an estate management company. Once the development has been completed and the house builder has sold all the homes, the unadopted communal infrastructure will be transferred to the estate management company and that then takes over the maintenance moving forward. Now, there are two different types of estate management companies usually found on new build estates. The first and increasingly common is the owner's management company. Now, an owner's management company is set up by the house builder specifically for the estate. And the members of this management company are often homeowners that are on the estate, besides the initial founding members who will be employees of the house builder to begin with. Now, there are two types of owner's management company. You can have a company limited by guarantee, which is often not for profit, so there's no money-making scheme out of this, or a company limited by shares. With a company limited by shares in this situation, there's not always a requirement to have a share certificate. The key differences here is that a company limited by guarantee, depending on the articles of association, which are the rules of a company, homeowners may either need to put in an application form to become a member or may automatically become a member when they own a property. The owner's management company is often preferred as it gives greater control to people living on the estate or people that own properties on estate. They can collectively make decisions on the services that are required, the levels that are needed for the estate, and any particular areas of concern. And most importantly, they can control a bit more of the costs involved. Now I'll hand over to JP, who will discuss the second type of management companies.
Absolutely. So the second type of management company is a private management company. I'm seeing these popping up more and more frequently. I know that they've been around for many years, and I know that they're particularly prevalent in, say, Scotland, but they've certainly started moving south of the border. I've had these come up on a few of my schemes recently. So the private management company that I'm talking about here is one that is a for-profit private organisation whose main business is the running of housing estates on behalf of, well, not on behalf of the residents, they will run the housing estate communal parts. Some of the bigger names out there have hundreds upon hundreds of estates all falling within their portfolio. And I think the reason that I'm seeing an increase in this type of structure is that there is quite a burden being placed on private market and RPs, market owners and RPs, to manage their own estates infrastructure by having the residence management company. And I think that house builders are perhaps seeing it as almost a selling point to, rather than require their purchasers to become members, to become a director or secretary and to take an active role, they will instead appoint a third party professional organisation to take all of that burden away from them. The problem we have with that is that, well, a problem that can arise, with that approach is that you are taking, as Katie mentioned, all control that residents could have had about the future running of their estate and passing it into the hands of private individuals with absolutely no personal connection to the estate in question. So unlike a resident-controlled management company, the residents and the RP will not be a member or shareholder and consequently have very little, if not no control over costs and services provided. And as a result, this is generally regarded as a riskier approach in comparison to an owner's management company. Each private management company will also have its own bespoke requirements to securing the payment of the estate service charge. After all, being able to recover the service charge from the residents is the way that they're going to keep their business going. We often find that by the time we see the first draft transfer, say on a Section 106 acquisition that I do for an RP, that the private management company will already have dictated to the house builder the very precise terms that need to go into this transfer deed. These terms are probably connected to an existing contract or service level agreement between the house builder and the private management company. And ultimately, that really curtails the house builder and their solicitor's ability to negotiate terms around the service charge provisions with the RP and their solicitor. In the past, this has led to matters either becoming abortive or at the very least protracted negotiations, because we've needed the house builder to convince the private management company's representatives to join the discussions and the negotiations. Certain particular aspects I see crop up time and time again are the timeframes from service charge demand to payment of the service charge. RPs on this call will be well aware that compared to your average market purchaser, an RP cannot just draw down funds and settle invoices on demand. They do require decent lead-in time, 21 days, 28 days, and so on. Yet these private management companies haven't necessarily allowed for this when agreeing terms or imposing terms on their house builder clients. We also find that depending on the management company appointed, the mechanism for house homeowners to actually remove the management company can vary from provider to provider. There should always be a mechanism, because no estate should be bound to forever and ever use a specific management company. say, for example, that management company may itself go under in the future. But for obvious reasons, no matter which management company we deal with, the provisions that are included in the transfer deed to oust them, shall we say, are often quite favourable to the private management company. Quite often we'll see that a vote will need to have taken place, whereby a certain threshold of all plot owners will need to have voted in favour of removing a management company. I've seen in recent times that even if that vote threshold is reached, the whole process could be defeated by there being just one market or any purchaser being in service charge arrears. If you've got an estate where you are one of, say, 100 other plots, and you need to have 2/3 of those plots vote in favour of removing the management company, that's one threshold, rather hard to meet. And secondly, 99 out of 100 plots could have paid their service charge. Plot 100, however, that plot on the estate that doesn't do anything by the book, could completely defeat any ability for the remainder to kick out a management company. And of course, the RP on the site is quite likely going to be one of the majority landowners on a majority plot owners across the site. And it's more likely than not going to be yourselves, the RPs, who pick up on the failings of the estate management company, perhaps want to take, well, not they want to, but will find yourselves taking the lead in trying to make good the issues that the estate is suffering. And it'll be a tremendous burden on an RP to have to run this mechanism. Our advice ultimately then is that where at all possible, if an RP is discussing a prospective purchase with a house builder and learns that the house builder is intending to appoint a private management company, that the RP get hold of the potential terms that management company is going to impose on the house builder, and if necessary, fire it over to us to have a quick look before anyone is firmly appointed. That way we should be able to nip in the bud, or try to at least, any potential pitfalls in the house builder proceeding with that management company. I'll now pass back to Katie.
Thanks, JP. Now, the most important question, I'm sure lots of you are thinking, is if there's an owner's management company, do we have to become members? And unfortunately, yes, you do. There is no option here. If an RP acquires a single home or multiple homes on a new build estate, where there's an owner's estate management company, they have to become members. If not, the whole idea of the scheme just fails. You'll end up in this position where parts of the estate aren't being maintained at all, and it's just going to fall apart. Now, if you have to be a member of a management company, the next question is, what's the liability? Now, the main liability of being a member of a management company or an owner's estate management company is limited to the amount contributed in the event of it being wound up. In cases where you've got companies limited by guarantee, this is usually limited to £1. But again, this varies from each estate depending on how the owner's management company is set up and confirmed in the Articles of Association, but often the risk is minimal. Most new build transfers are drafted so all members of the estate management company must also agree to become directors or company secretaries. Now, as some of you may be aware, the liabilities and obligations of directors can be really extensive, often more so than just being a member of the estate management company. For that reason, lots of RPs will generally be resistant to this idea and won't want to become a company director. And generally, it's advised or it's recommended that this is discussed and negotiated at the transfer level to see how this can be worked around. Now, if an RP does become a member of a management company, as JP's alluded to previously, you'll be entitled to a vote depending on the articles of the company. This may be one vote per owner on the estate or one vote per the number of properties acquired. Now, the more votes an RP has, and obviously the more control they have over the decisions of a company. But as JP has discussed, there's lots of positives and negatives coming from this, and it should be really carefully considered on each estate, on each scheme that's discussed, to see whether RPs will or won't want to do this, because as I say, there's so many different factors to be involved with. But I'm now going to talk about providing the services in these estates and how the estate charge works. So as we've seen, estate management companies are set up to manage, maintain, ensure and replace these communal infrastructure on estates over time. Now the cost of these works are recovered from the homeowners on the estate by way of an estate charge, also known as a management charge or service charge. Now, it will be a contractual obligation to pay the estate charge, and it will almost always be found in the freehold transfer of the homes. The estate management company will ideally be party to the transfer and will covenant to provide the estate management services, and the transferee, often being the RP, will covenant to pay this estate charge. Now, the estate charge payments vary from each estate, and JP's noticed on this previously. It might be that it's paid annually, biannually, or even monthly. And there's usually an accountancy exercise undertaken each year to see if there's any credit or balance sort of on the account for each homeowner. And it's recommended that the terms of each transfer is reviewed and considered on an estate-by-estate basis to see the exact payment terms. And as noted previously, there may be very short periods of payments and transfers, so you should try and ensure there's sufficient time to pay these, because as JP has said, RPs aren't going to be able to transfer money and pay these on demand. In most cases, the estate charge is invoiced to the RP as freeholder, and then when it's possible, RP should recharge this in a proportionate amount to the tenants and leaseholders of the properties on the estate. I will now pass you over to JP.
Look out. Now, woken you all up. There were, obviously, we've talked about all kinds of things so far that you need to look out for, but there's more, I'm afraid, because that's just the nature of estate services. Point one, is there a reserve or sinking fund in the draft service charge budget that you've received, say for major repairs? Major repairs could be road resurfacing. So if there's an extensive private estate road that isn't going to be adopted, is the management company making allowances on an annual basis to create a reserve fund for when the inevitable resurfacing has to happen in, say, 10, 20 years' time? If there isn't one, should there be one? Because we really don't want that unwelcome surprise in the future where suddenly your annual estate charge of £230 is suddenly quadrupled, say, if not more. We need to look out for exactly what communal infrastructure is being covered by the estate charge and how complex it is to actually maintain that infrastructure. Maybe the sewage treatment plant on a site is being kept private and won't be adopted by the water authority. Well, are there adequate arrangements in place to ensure it's properly insured, properly managed? Do we know where to find the expertise to step in and fix a sewage treatment plant? Because my goodness, I'm certainly not getting stuck into that. And really, is your average resident director going to be switched on enough to know when things need to be serviced and maintained? Is there a managing agent? So this, just so we don't get confused, obviously a managing agent definitely differs to the private management company we've talked to, but a managing agent itself is likely to be a private company that specializes in managing estates. But where they differ is that they will manage the estate on behalf of a residence controlled management company. On smaller estates, owners may want to run the services themselves and not appoint a managing agent, because with the appointment of a estate management agent comes some considerable cost to the residents. But again, I think it all comes down to what expertise is needed to successfully manage the estate. What machinery is needed to mow the huge area of private open space, for example. We've talked about watching out for a private management company, but we also need to look out for rent charges. An estate service charge is not automatically the same as what's called a rent charge. A rent charge gives a rent charge owner the ability to recover possession of a home if they default in the payment of that rent charge. Rent charges used to be a more widely used thing. They are starting to dwindle somewhat, but do remain prevalent in some parts of the country. But say in the east of England where we are, I've not seen one for a long time, frankly. And because of that point, that if you have a rent charge on your property rather than a contractual service charge, and the rent charge owner could repossess your property, funnily enough, mortgage lenders do not like them at all. And aside from scrapping the idea of a rent charge, if there has to be one, there needs to be some specific protective mortgagee protection wording included in the transfer to stop the home from being repossessed without the lender first having the opportunity to step in. And yes, although there is a distinction between a private contractual service charge and a rent charge, the lines can blur. And again, erring on the side of caution, some mortgage lenders are insisting on the inclusion of that protective wording in transfer deeds as a belt and braces approach, or should I say at least an express clause in a transfer that confirms that the service charge is not a rent charge. Wow, and if we thought that was going to start getting complicated, and that is in particular one area that we could probably do an entire webinar on, oh no, we're not going to soften the tone. We're going to talk about regulation of estates, of freehold estate charges. Bear with me, everyone. This is going to be a very brief look at the position under the Landlord and Tenant Act. The Landlord and Tenant Act regulates leasehold estate charges. Note, leasehold. And your leaseholders have statutory rights to challenge unreasonable costs or service levels being levied against them by their landlord. Freeholders, however, who are being charged a service charge, do not have those same rights, and this area is not currently regulated. That means if there is a private management company where costs spiral and service levels are not as expected, then freeholders will only be able to look to the terms of their acquisition transfer to see what options there are, if any, to challenge a demand. And as I mentioned previously, it's often, in theory, possible to remove a private management company, but in practice, not necessarily the case. We try and take some comfort in the fact that the government has confirmed that they will be looking to reform and regulate this area, but unfortunately, it's certainly not high on their priority list. There's no current timescale that we're aware of for when this is going to happen, and it seems to be the case that it will happen when it happens, when parliamentary time allows. And I really don't think we can justify getting bogged down into the ins and outs in such a short time frame. But ultimately, if you do find yourselves in a dispute with one of your leaseholders over the level of service charge that you are trying to recover from them, you really must seek some legal advice. And obviously, there comes a shameless plug for our housing management team. And well, on that really happy note, Katie now has some key action points for RPs to take away from today.
Thanks, JP. So after all the things we've discussed, and after all the things to look out for, and the fact that it's not going to be regulated anytime soon, here's some key actions to try and make things slightly easier moving forward. So firstly, try and keep good records of all estate management companies that RPs are members of, and keep a record of infrastructure covered by the management company. So if an issue arises, it's quite easy to figure out what's to be managed and what's not to be managed. Try and monitor estate charge budgets as well and estate charge costs. As JP has said, it's difficult to remove private management companies, but keeping a track of how costs are going throughout time is really, really helpful. Try and make sure that estate charge invoices are paid by the due date. Obviously, if there's smaller time limits, then it's just trying to get a really good system in place to ensure these are paid by the due date and then recharge the tenants afterwards where possible. On that note, though, you should make sure to monitor any double charging that may take place, such as the management company sending invoices to the RP as freeholder, then also to an occupier by mistake. Where possible, you should try and monitor the service levels on estates and participate in management company meetings as and when it's appropriate to do so. And finally, on a positive and important note, try and engage with tenants and leaseholders. As JP said, we don't want to have a dispute. No one wants a dispute. Engaging with tenants and leaseholders, just discuss things happening on an estate, often is one of the best possible outcomes to begin with, to avoid things getting escalated. And that brings us to the end of our webinar, and I believe it's now time for questions and answers.
It is. We're very close to the end of the webinar, so I think we've got a chance to one, if not two questions. If we don't get to your question, we'll make sure we follow up with you afterwards. One has come in, and I have a suspicion it's because I probably appear to have been slating private management companies, and that wasn't the intention. But the question is, do you think there are advantages at all to private management companies over owners management companies? And I think I probably better take this one. And I think there is, absolutely there is. As I touched on, offloading the management of estate services to a private management company rather than imposing the burden on private residents certainly looks to be a really great aspect of going down that route. It could be a sales point. I suspect if it's set up correctly, an RP would probably welcome a private company taking all responsibility off them. But it just comes down to how the relationship between the plot owners and that private management company is managed, and it also comes down to how imposing in its terms is that private management company, and whether they're going to engage with us as the RP solicitor to compromise. And where I said it's been difficult and negotiations have been protracted, there is always some wiggle room with them. It's just you have to knock on the door quite a few times to finally get them to answer. And the second question, which I'm going to palm straight over to you, Katie, is a question generally about how the estate charge is paid in relation to affordable housing. So how does it differ then, depending on what the setup is for the affordable housing in question?
Thanks, JP. It's a good question. So for shared equity charge properties, the freehold owner is directly liable for the estate charge. On shared equity lease properties, the freehold owner is usually liable for the estate charge, but can be recharged to the leaseholder. However, we'd recommend you check the terms of the acquisition transfer to the RP and the terms of the lease in this scenario. And for shared ownership leases, the freehold owner is usually liable for the estate charge, but again, this is often recharged to the leaseholder.
All right. There are a few more questions, but we are unfortunately out of time. I will make sure we pick up those and sort of talk to those who asked the question. We'll pick it up with you after the event. But thank you ever so much for attending today's webinar. We will send everyone a copy of the slides, and the recording will eventually be made available online. At the end of the webinar, you'll be invited to fill out a feedback form. If you could please fill that in for us, it is really helpful. And if you've got any ideas about future webinars, again, please do drop us a note, and we'll make sure that we'll try and pick them up and incorporate them into future webinars. Keep an eye on LinkedIn for legal updates, but otherwise, have a lovely rest of your day, everyone. Thank you for attending.